All right, did everyone get a chance to speak with each other?
Yes, sir.
All right, and is there still missing information?
Can I guess, start us off, because I won't be able to finish, but the defense.
Well, let's go on the record.
Oh, sure.
All right. Court is on the record in 2023 CR 11510A, 11510B, and 11510C. Attorneys for state and defense are both present. And everyone, if you'll just remember to state your name so that the court reporter will have it. Yes.
This is Jeff Mulliner for the state of Texas. And so my understanding from witnessing the conversation and asking a couple of clarifying questions is that the defense is certainly interested in getting access to the evidence.com cloud-based software. And the court previously had a question, is that proprietary? And the answer we now know is yes, it is. And Jim Kopp is here on behalf of the city of San Antonio. And so, of course, in conferring behind the courtroom and the jury room, the question was raised, would the city have an objection to providing a username password to the defense so that they could access for themselves this proprietary software? And the answer that will be provided if asked is that yes, the city will object through Mr. Kopp. And so then the further discussion was trying to get at what is there that the defense is seeking that would be on that system. And at a minimum, my understanding is that there would be entries that could be made by officers, either administratively or otherwise, that could be referred to categorically as either bookmarks or comments. And the suggestion is that a piece of paper could be printed that would include a bookmark and additionally a comment if such a comment existed. So now what is on this proprietary software could be reduced down to a document. And then when the question is raised, would the city have an objection that they would raise with respect to releasing those documents? And the answer is affirmative. Another question was raised, how long would it take to acquire documents establishing the bookmarks and the comments, if any, that exist with respect to what we're talking about here, 42 separate and unique body cams, and not being facetious, because of course we're among ourselves back there, but the answer is probably quite a bit of time, like an unstated.
Oh, well, let me just tell you, if this exists and if it is in document form, or it could be given in document form, then it needs to be given in document form. Here's my question. How long has Attorney Cobb been working in the position that he's working in? I mean, it's been more than since January, right?
I'm guessing over a decade, but I don't really know.
Well, no, the reason why I asked that is because he's been in the position for longer than January. Discovery in this case has been going on since January. He's been in that position at least since May, when the acknowledgement of discovery was done. And everybody is just now saying, oh, we don't have this. So print it out, give it to them, or either do it by, and if somebody wants an order for the court to sign, I will sign, print it out, give it to them, or either let them view it under the watchful eye or whoever has access to the information. But that's where we are. And everybody has much more than 10 days to make that happen.
I was
Your Honor, may I address the court?
Oh, well, after he finishes, then I'll allow you to address. Everybody will have a chance to put whatever they want to put on the record.
sure. And so I was just kind of trying to highlight for you what what you would have learned if you were a fly on the wall back in the room. Really just kind of summarizing.
Probably a butterfly, not a fly.
Of course, absolutely. So the conclusion is that yes, what is included as bookmarks or comments on these 42 body cams could be identified and printed onto paper. How long would that take? Not able to say with the collection of individuals we had back, that there was nobody that could definitively say this is how long it would take. We then further learned that there is a person that would have likely the greatest amount of education, training, and boots on the ground experience with these matters. And as I understand it, that would be a Sergeant Bobby McGee. So I think we've identified a person that is ripe for bringing into the discussion among the parties trying to resolve this. And so that's really all I was doing, is kind of summarizing for you what was discussed back there. And that's
Well, I'm
about
not
it.
even counting today, but with weekends, that means that y'all have 16 days before the 20th, which is when jury selection will happen, for everybody to have that.
Mr. Kopp indicated that his last day before he will be absent for 3 weeks is this Friday. And I learned that there's not really somebody that is designated to replace his unique duties when he is not in. So I'm just letting the court know that he has indicated that it would be his intention to object to direct access to evidence.com by the defense, and would also be indicating his intent to object to these documents at such time as they could be created. And we don't really know how long that would take, but maybe
Well,
he has a better
Then we're
idea.
going to count today at, what is that clock say, 2:32? People need to start printing that to get that ready. And then the court will make its ruling on that. But I can tell you this, the defense should have that to view it, to see what's on it. I don't know why people waited to the last minute to do this, but this is where we are. And what I'm telling parties, September 20th at 9 a.m., this case, we will be having jury selection. Now, I don't know why I had to be the person to discover that this software is proprietary. I don't know why I'm the first person to ask that, but I have asked it. They're saying that they're able to print out whatever, then I can understanding them on my knowledge of items that are proprietary. I can understand why they would not want to give them a password and code to get into the system. But they need to print out what they're saying that they want as it relates to this case. You can turn it over to the court. I'll review it and see whether or not it's something that the defense should or should not have. That's where we are. But this case, the voir dire is happening on September 20th. So everybody, you have today, Wednesday, Thursday, and Friday. And when it comes to people in their employment, this is what I always ask people when they say, oh, this is the only person who can do it. And you know what I say, God forbid something were to happen to that person. You're just telling me nothing's going to happen. That job is done. It's like, oh, if something were to happen to this heart surgeon, then nobody else can do heart surgery. We're just done. Nobody's irreplaceable. If something were to happen to me tomorrow, you telling me there are not going to be any cases heard in the 187? Yeah, they'll find somebody to replace me. Everybody's replaceable. So if Attorney Cobb is not going to be here, there's somebody else there. If not, when he retires, I guess people will pay him billions of dollars. Please don't retire because you're the only person who can do this. I don't see that as the case. Although I admire you, Mr. Cobb.
I can. This
Oh,
is
yes,
a little
please.
theoretical. We believe we can do the download, and I'm going to find out real fast.
Thank you.
If I decide to file a motion to quash, I will do it in the next day or two.
Okay.
Rule on it without my apps. I don't need to be here. I trust the
Okay.
court.
All right, well, let's if you're gonna do that, then let's file it today.
That's what I'm
I
sorry.
mean, I'm sorry, if you're gonna do that, where you want to do a motion to quash, then let's file it today. I'll hear it at 9 a.m. tomorrow?
I'll try to do it today. I just found out about this at 1 o'clock and this download has never been done before
Okay.
pursuant to a request of
Oh,
defense.
look at us. We're making new
It can
things.
be done. I just don't know.
All right. I
So I don't
appreciate
want to
it.
make a promise, but
All
I
right.
think it can be done.
All right. And I'm sure that nobody will object if you want to do an oral motion to quash. And if you want to, Mr. Cobb, if you want to zoom in, I'm sure no one will have any objection to your zooming in if you decide that you don't want the defense to have whatever materials it is.
Well, I'll bring him for an in-camera inspection.
Okay, awesome. And so can you have that here tomorrow by 9 a.m.?
Let me put it this way. If I can't get them all produced, I'll get some produced so you'll know what we're talking about.
Okay.
And then they can continue the process.
All right, awesome. Then if you can even have it here this afternoon before 5. Let's try. We'll all be here. We'll wait.
Really pushing, but I don't know, but we'll do what we can.
All right, let's see if we can have it here before 5. If not, if you'll just contact the court. Does anybody have any objection to me giving Mr. Cobb my cell number? He may still have it from when I was in the DA's office, but just to call me to let me know if he'll be able to make it back by 5. Any objections?
Of course not. We have no objection.
Defense?
No, Your Honor.
All right. Mr. Cobb, let me give you my cell.
We have it. I
Maybe
kept all
you
the,
may.
I kept all the, yeah, I'll let you know if I can get where we're at.
All
Be
right.
excused.
Yes, thank you so much.
See you guys.
All right, so everyone, we'll take a recess.
I had
Yes,
a matter of housekeeping. Did you
of
want
course.
an order prepared? And if so, what dates or deadlines or times? did
Oh,
you
well,
want?
let's see if he has it here by 5. And if he has it here by 5, I'll review it. And we're gonna stay here. It won't take me that long to review it. I'm a quick reader. And then I will let you all know today before we leave court today.
Do you want us back by 5 or do you want us to check with the coordinator to see if we should be back?
No, I mean, we're gonna be back by 5.
Okay,
All right. And what I'll do is, I think I have some of your numbers. If everybody will leave their cell number with me, and I'll include everybody in the group chat. I believe, Mr. Lunan, I think you have my number. I know David has my number. So if you all can coordinate and put everybody in one group chat with me, and that way I can text you all and say, Attorney Cobb is here, come on back. And I don't think people are going to be traveling that much anyway, because my understanding, it's flooded here in San Antonio. Major flooding. I think I may have your cell number too, but just in case. Thank you. All right, so is there anything else?
may we be excused until 5?
Yes.
Thank you.
And just if you all could stay maybe within 20 minutes or so, because he may be able to tell us something before 5.
Oh, it's that late already?
Well, it's almost 3.
Okay. All right, we'll be in the hallway.
All right, sure. And if your clients have somewhere else they need to be, if you want them by Zoom, they can be by Zoom instead of staying. All right.
Okay, thank you.
All right, thank you. All right, we're going to go on the record in 2023 CR 11510A, 11510B, and 11510C. Parties for the state and the defense are present, and so are the accused. All right, so the court received a phone call from Attorney Cobb. Attorney Cobb said that he will do a printout. He will hand it over to the state, and state you to hand it over to the defense. He is saying it will take approximately, I think he said he would try to get it here today, but it's going to take about 30 minutes per transcript. And I think he said it's maybe 15 or 16 transcripts approximately. So state, if you want to call Mr. Cobb and see exactly what time he will be bringing the transcripts to you, and then state if you'll make copies of the transcript for defense counsel. And he said that he will not object or raise any objections or file a motion with the court. All right, anything else? Yes.
Nothing from the defense.
All right. And I'm assuming that's nothing from all the defense attorneys?
Tom Nisbet on behalf of Alfred Flores, nothing from us, Judge.
Ben M. Cifuentes Jr. for Eleazar Alejandro, that is correct.
All right, so then state, if you will call Mr. Cobb to see specifically what time, and then you all can make arrangements to give copies to the defense.
Is this gonna be in hard copy or digital format?
It will be in hard copy. That's what my understanding was, but to clear that up, if you will call and make sure, but it's my understanding that he is printing everything off. All right, is there anything else?
So the court doesn't anticipate us reconvening here before you today, just the arrangements as you've discussed between the state and the defense.
Yes.
Okay.
Because my understanding from Mr. Kopp, well, not my understanding, Mr. Kopp called me, which no one had any objection to him doing. And he said that he is not going to raise any objection to turning the evidence over in hard copy. And he informed the court that he would print that out, make sure that it is delivered to the state so that state can give copies to the defense. All right, so state, if you will call Mr. Cobb as we sit here and see if you can get some sort of ETA, and then that way you can confer with the defense on when specifically they'll have it in their hands.